Hi, I'm Darlene Wanger from Kaplan Wanger, a family law firm in Los Angeles, California, specializing in divorces, custody matters, financial matters, premarital agreements, post-nuptial agreements, and also collaborative and mediation. Okay, the difference between a prenuptial agreement, also referred to as a premarital agreement, and a post-nuptial agreement is a premarital agreement is an agreement entered into between potential spouses in contemplation of marriage with respect to present and future property rights, whereas a post-nuptial agreement is an agreement entered into by spouses after marriage. So if you don't have a lot of money or resources, the question is always asked, is it necessary to get a premarital or a prenuptial agreement? And there's really no one right answer to this question, and it really depends on the facts of each case. And so a premarital agreement might be more beneficial for one spouse over the other. For example, a potential spouse, let's say that's the woman, may own a business, and at the time that she's contemplating marriage, she might not have a lot of money, she might not have a lot of resources, the business might not be really valuable. But later down the line, the business could be worth a lot of money. And had she entered into a premarital agreement and she stated in the premarital agreement that the business would remain her separate property, and her husband did not acquire any interest in that property, then at the time that they divorce, then he will have no interest in the business and he'll get no money from that business. So in that example, the woman would have value from having a premarital agreement, whereas the husband would have been better off if there was no premarital agreement. Well, under California law, both prenuptial and postnuptial agreements entered into California can dictate property rights both during the marriage, in the event of a divorce, or even after death. For example, potential spouses could enter into an agreement, either a postnuptial or a prenuptial agreement, where they might decide, let's say it's a second marriage and both spouses or both potential spouses own homes, they can enter into an agreement where they agree that wife's house will remain her separate property and husband's house will remain his separate property. And a lot of people do this because they want their children to inherit their property after death, or in the event of a divorce, they want their children to be able to have their property and not their potential spouses. And in addition, parties may be able to waive or limit spousal support obligations in the event of a divorce in a premarital or a postnuptial agreement. However, under the current law in California, the waiver of spousal support may be unenforceable if one party is not represented by an independent counsel, or the spousal support waiver is found to be unconscionable at the time that enforcement of that waiver was sought, like in the event of a divorce. Under California law, both prenuptial and postnuptial agreements entered into California can dictate the property rights of spouses in the event of a divorce, during marriage, and even after one spouse dies. And under certain circumstances, in a prenuptial or a postnuptial agreement, a spouse could waive or limit spousal support. So as for what cannot be in a prenuptial or a post-nuptial agreement, you cannot have any terms that is promotive of divorce or unenforceable under public policy grounds. For an example, one case says that you cannot have a premarital agreement whereby husband, let's say, agrees to give wife $500,000 only if there was a divorce, because the idea of that is this agreement would have the effect of encouraging divorce, as the wife would say, boy, I can get $500,000 if I divorce my husband, so why not do that? And parties also cannot enter into agreements penalizing either spouse for fault during divorce. So, for example, you can't have an agreement where it says that, you know, if wife has an affair. You cannot have an agreement which states that if wife has an affair during marriage, that husband would be entitled to $10,000, because under California law, there's no fault divorce, and so that would violate public policy underlying no fault divorce under California law. And parties also cannot enter into agreements divesting jurisdiction of child custody matters. And so that basically means that while parties can say, yes, you know, we want to raise our children under a certain religion, or we think that a 50-50 custody arrangement would be best. And then if you go to court and you say, no, but we agreed to that in our premarital agreement, so the court can't make a decision, that would be unenforceable, because the court always has a right to make decisions over custody matters. And in addition, you cannot waive child support or limit child support in a premarital or postnuptial agreement, because that also, under California public policy, child support is for the child. So any agreement waiving it or limiting it is against public policy and non-enforceable. Yes, you know, we want to raise our children under a certain religion, or we think that a 50-50 custody arrangement would be best. And then if you go to court and you say, no, but we agreed to that in our premarital agreement, so the court can't make a decision, that would be unenforceable, because the court always has a right to make decisions over custody matters. And in addition, you cannot waive child support or limit child support in a premarital or postnuptial agreement, because that also, under California public policy, child support is for the child. So any agreement waiving it or limiting it is against public policy and non-enforceable.
Right. And what are the pros and cons of a prenuptial agreement?
One of my colleagues has a really good answer to this question, which I'll try my best to reiterate. So if you're entering into marriage in California without a prenuptial agreement, then you are choosing to divide your property and determine other marital rights, such as spousal support, pursuant to California law. However, if you enter into a premarital agreement, you are choosing how you want your property to be divided and other rights and responsibilities pursuant to marriage, which could differ from what California law dictates. So either way, you're entering into a premarital agreement. Just one, you're entering it into without making an informed choice. And it might be a choice that's not suited for your needs and is not contemplating what you want in the future for your property and for other marital rights. However, every case is different, and it might be more beneficial for some people to be married under California law and to be divorced under California law. It's basically what's best for each person. But I think, knowledge is power in this situation. And one of the cons about a premarital agreement, which, as a family law attorney and somebody who has somebody come into my office and to either say I want a prenup, or my potential spouse just presented me with a prenup, is that it's a really awkward and uncomfortable situation. Basically, under the standard process, and, let's say it's husband hires an attorney, and then, he tells wife, like, hey, I want to enter into this premarital agreement. So my attorney is going to give you and your attorney this agreement that we drafted. And then the attorneys get to haggle over it. And a lot of times, people are really upset because they feel like they're not being heard in the process. They feel like it's not going to be fair. And one of the newish developments in California law, and actually in other states as well, is called collaborative law. And it's a less adversarial process where basically each side is represented by an attorney, but they also maybe have a coach, like a mental health professional, maybe a financial person, and they all meet together and they all discuss what everybody needs. And it's people working together collaboratively to come up with an agreement that meets everybody's needs and to also discuss everybody's feelings. It's a little more touchy-feely than the standard adversarial process. And I actually think it's a better process for people who are contemplating getting a premarital agreement, because then everybody everybody's issues are put out on the table.